Okay guys, I've got some case law now. Why this is important, this is federal case law. So what this means, when they make decisions or clarifications in the federal courts, the lower courts, including the state's courts, are supposed to take and adjust their rulings and everything else based off of those definitions by the higher courts. Let me read you something here. Recently in the Ninth Circuit Court, a case also held there is no exception to the warrant requirements for social workers in the context of a child abuse investigation. Zero. The regulations they cite require social workers to respond to various contacts in various ways, but none of the regulations cited say that the social worker may force their way into your home. That's called coercion or force, either one, without a search warrant in the absence of any emergency. In other words, it has to be justifiable and there's a case of emergency, not, well, we needed to or we wanted to, or, of course, my favorite one I love to hear out of them, well, I have a report and this is my job. No, sorry, you just broke the law. Matter of fact, that's called deprivation of rights. That's a felony. So you are committing a felony. When you do this, social workers, that's enough for you to go to jail. Let's continue on. Calabretta versus Floyd, 189 F3D 808, 9th Circuit, 1999. And I know I'm putting that stuff out there, but that's so you can reference and look up and realize these laws have not been overturned. In other words, they are active. Calabretta also cites various cases from other jurisdictions for its conclusion. Good versus Dauphin County Social Services, 891 F2D 1087, 3rd Circuit in 1989. It held that a social worker and a police officer were not entitled to qualified immunity for insisting on entering her house against the mother's will to examine her child for bruises. Good holds that a search warrant or extenuating circumstances, such as the need to protect a child against imminent danger of bodily harm or bodily injury, was necessary for them to enter without consent. And the anonymous tip claiming bruises was in the case insufficient to establish it as being a special extenuancy. In other words, they didn't have a right and they tried to BS their way in, and then they tried to BS their way in the court, and the higher court said, nope, that don't work. That's a poor excuse and we're going to stand by the Constitution.